and I stand guided by Article 49(1)(h) of the Constitution of Kenya, Section 123A of the Criminal Procedure Code, and the Judiciary Bail and Bond Policy Guidelines. So bail bond pending trial is a constitutional right for an arrested person. The prosecution has not objected to the same, and no material has been placed before me to warrant a denial of bond. That said, it will be a mockery of justice to release the accused on personal bond based on his reputation as a TikToker without any regard to the provisions of Section 123A of the Criminal Procedure Code. Therefore, in consideration of all the above, bond is set in the following terms. The accused may be released on a bond of 100,000 with one surety or a cash bail of 50,000. On the second issue, the prosecution has argued that the accused is a self-proclaimed street activist with over 130 social media followers. And before his arraignment to court today, he had posted a video talking about the case, and it had been republished by other social media users. This, they argue, this conduct, they argue, undermines the integrity of the judicial process and poses a great risk of sub judice. Counsels for the defense argued that no such evidence has been presented before the court to prove the allegations by the prosecution, and they urged the court not to gag the accused, who has lent his voice to air the plight of the voiceless. They offered a compromise to have the accused refrain from publishing details of the trial and publishing any documents touching on the case. It is always the case that a matter before a court of law ought not to be tried in the court of public opinion. This is so as to guarantee the sanctity and integrity of the proceedings before that court and the dignity of the court itself. It is on record that the accused is a blogger, a human rights and street activist. He uses his social media platform to expose issues of public interest. This is as stated by his counsel, and gagging his platform will be a violation of his freedom of expression. Rights and freedoms are, however, subject to limitation under Article 24 of the Constitution, which provides that these rights may be limited to the extent where the limitation is reasonable and justifiable. The prosecution has not sought blanket gag orders. Their prayers are specific to the case at hand. The accused's enjoyment to his right to freedom of expression needs to be balanced to ensure they do not prejudice the rights and freedoms of others. The complainant has a right to not have his case tried in the court of public opinion. He has the right to privacy and the right to a fair trial. The gag orders are therefore necessary to preserve the integrity of the complainant, the sanctity of the court proceedings, and the proper administration of justice. So a gag order is hereby placed against the accused, forbidding him, either by himself or through proxy, from discussing, writing, publishing, circulating, or causing to be written, printed, published, or disseminated in any manner any matter relating to this case through any media platform, whether on paper, electronically, including television, radio, website, internet, and any media at large. Those are the orders of the court. So I can give you a mention date for pretrial. Yes, Counsel.
They have taken away his first phone on the first day, and they took away the second phone yesterday. So the first phone was returned this morning. The second phone has not been returned. We pray that the court orders the police and the complainant.
Taken by whom? Ms. Rama? I'm still writing her submissions.
Yeah.
Mm.
Wednesday 13th. Your Honor, the issue of Co-operative Bank was explicitly admitted by the counsel for the complainant.
Ruling. Sipaka ni publish.
Next one, no?